Everybody, and welcome to today's Brachers Bitesize webinar. I can see that we have quite a lot of people here today, so I think we might have touched on a topic that is, let's say, a hot topic at the moment within the world of employment law and HR. We're going to run through what limited help and assistance we might be able to offer in the area of grievances and disciplinaries in the age of AI. Before I get into today's actual session, if you've been before, if you know how to metaphorically put your hand up, if you could do so just so that I can make sure that the audience can hear me today, that would be much appreciated. Good, I can see some hands, so good, I've pressed the right buttons, which is a start, so they're not going to be able to replace me with AI just yet. Right, what we're going to look at today is where we're at with AI, grievances, employees' use thereof, etc. For those of you that may not have been before, my name's Colin Smith. I'm a partner at Brachers. I've been an employment lawyer for 20 plus years, so hopefully I've learned a few things along the way. There will be a copy of the slides made available. You don't have to write everything down as we go through. As those of you know, we tend to go through at a fairly rapid pace in the half an hour available, but there will be copies of the slides and a copy of the recording of the session should you want to look back at it separately later. Okay, so just a brief overview. When we talk about AI, what are we actually talking about for a moment? Now, I'm not a computer specialist, I'm not a technical specialist, so I got AI to tell me what AI is, okay, and what the different types of AI are. What we mostly deal with at the moment, from an employment law and a HR perspective, is what is called generative AI. That is what ChatGPT, that underpins Microsoft Copilot, that underpins the leading providers of AI that we've all heard about, use. It's called generative AI. They're based on what are called large language models. Okay, they're not what are called agentic AI, which is the next level, the next evolution, which is the sort of AI that will drive your self-driving car and deliver your self-delivering Amazon drone and so on, and can, to a greater degree, think for itself and act for itself. And we're not yet at general AI, which is when it starts to replace us. Okay, so where we're at the moment is this, what's called machine-based learning generative AI, which is basically taking a lot of data and presenting it back to you in a smarter linguistic way than it's ever been able to do so before. But critically and importantly for what we're dealing with, it can hallucinate, as they use the technical phrase. In other words, it can make stuff up, okay? And we'll look at to what degree that causes a problem in a minute. The stuff that we use primarily and that your employees are using primarily is designed to perform specific tasks, create questions, generate text, help with coding. It sometimes has context, but mainly it won't have past context. It will only have current context that you've fed into this current chat with it, okay? And they're largely passive. They're obviously not proactive systems taking action of their own accord, okay? They are, as you will also may be familiar, obviously trained on large data sets. In other words, they're trained on the internet, okay? And when they first came out, they were only trained on the internet up to 2 or 3 years ago, which meant obviously their data was pretty unreliable. Now they tend to be trained on data that is far more current, but it is still the internet that they're drawing the vast majority of their education and information from, and as such, they're about as reliable as the information you get from the internet, okay? And they accept themselves. This is not my wording, this is the wording of Copilot, telling me that it knows it generates false, misleading or fabricated information that can sound plausible but is not accurate. That's Copilot's own acceptance of its limitations, okay? Because what they do, and this is critical, they look for patterns in data, but they don't understand what they're looking at, and they don't fact check any of it, okay? So they take what they find on the internet almost as gospel. That's what they take it as. It's correct, here it is, thank you very much. And as you may have seen, you'll all experience this, that means you get very confident, very certain, but quite often completely incorrect answers, okay? And you quite often get them blancmanging different facts together that simply don't fit together. So there are severe limitations for what the technology can do at the moment, particularly when it comes to issues of law, good HR practice, and complex matters, okay? And it's not just HR that get this wrong. There have been now already a number of lawyers who have waltzed up to court with cases proudly in their submissions to find out that those cases are a hallucination and they don't exist. In this case, a pupil barrister, unfortunately quoting a case that didn't exist. And in this case, a solicitor submitting 45 case citations, of which 18 didn't exist, all generated from AI and not necessarily properly checked. Okay, so if we're capable of doing it, you can be certain a number of the grievances and disciplinary submissions that your employees are coming up with are going to be equally capable of it. Interestingly enough, I did a little bit of looking, and this is research from Harvard, who, hopefully a decent piece of academic research. The link's at the bottom should you want to go and check the research for yourself. But quite frighteningly, in 2024, what it said is when you use these types of models for complex legal matters, complex legal research, they can hallucinate 58% of the time. In other words, they are not a very reliable tool for the type of work that they are being used for when it comes to employees trying to throw the law at you in grievances and disciplinaries. Okay. Give you an example, because I came across this the other day, just to give you some real world example of what I mean by how inaccurate these things can be. I put a question to Copilot and I asked it which section of the Trade Union and Labour Relations Consolidation Act 1992 says that the expiry of fixed term contracts are not covered by section 188, which are the collective redundancy laws. I know that when a fixed term contract expires at its normal end date, there's an exemption in the Act from the provisions of section 1188. And I know that because I'm an employment lawyer. Okay, so I asked Copilot, where's that covered in the Act? Because I couldn't find the right section. Okay, it confidently told me that there is no such section. It told me it does not explicitly exclude fixed term contracts. To be fair to it, it went on to reference a case called Sterling, which is the case that said fixed term contracts are excluded, but it confidently told me the Act doesn't contain a provision. I went back in a slightly grumpy mood, so if AI does ever take over the world, I'm in trouble, and said that's completely wrong. It does contain it, incomplete with typo. Please try again. Typo was actually in the prompt. Okay. It came back and said, thanks for challenging that, but no, there's still no provision. There's still no express provision in here that deals with that, but there is this case. I went back again going, no, you're wrong, try again. And it said, thank you. Thank you for correcting me, but actually you're right all along, there is a section, it's section 282. That just gives you a very short and succinct idea of the reliability for legal matters of AI if you don't know what you're doing in the first place. Because had I not known what I was doing in the first place, I would have no doubt accepted one of those first two answers and been wrong. Okay, and this is the challenge we face in HR with disciplinaries and grievances, is that your employees are using them to generate arguments and submissions that they don't understand and that they have no understanding of whether they're actually accurate or not. But the computer has told them they are with absolute confidence. Okay. I then asked it to look at a more grievance complaint, just to give you some examples. I'm sure most of you here today have seen examples of AI-generated grievances or AI-generated correspondence, but just to give you a very quick example, my simple prompt, write me a strong grievance complaining about the fact I've been discriminated against and mistreated and not paid my overtime properly. And what it did was produce me a very nice looking letter. We're all starting to get a feel for what these look like because they all look very similar at the moment. They all have nice headings, they all have similar paragraph structures, and as we'll see in later ones, they do like to bold things, and they do like a sort of a tick box emoji quite a lot of the time. But it's set out a quite professional sounding grievance, but as is the problem with a lot of the grievances we're seeing produced by AI, they're very high on submission, but they're very thin on fact. They're very thin on actual detail as to what happened, when it happened, where it happened, who it involved. And that's because it leaves that bit to be filled in by the employee and they don't ever fill it in properly. But it does produce a professional sounding document. And then with the various recommendations and the bullet points. So that just gives you an idea of how easy it is to produce a fairly convincing sounding grievance, but when you actually dig under the surface, it's very thin on actual substance. My next prompt, write me a letter challenging the fairness of a disciplinary process against me with supporting case law, including allegations of bias, breach of human rights, because that must surely be in there, and failing to follow the correct legal process. In other words, give me something to try and help me defend myself against this ongoing disciplinary process against me. And this is where it gets a little bit punchier. So I'm writing to formally challenge the fairness and lawfulness of the disciplinary process. Oof. It does tend to have a habit of writing in fairly emotive and strong language, okay? Fundamentally flawed due to these various factors. But to give it its due, it does like bold letters, actual and perceived bias, but it has actually quoted correct case law on this occasion about what is the test for bias and how that applies, and it's set that out. It's also at the moment, because of my settings, showing you where it's getting the references from. That's what the bits in brackets for Bevan Britain, for example, or consensus. If that's showing me the sources, because I, when I use AI, will go and then check those sources for obvious reasons. But it is setting out a quite convincing on the face of it argument about how I've not had a fair hearing, I've been denied legal representation, failing to address the fact that in 99% of cases you're not entitled to it. Okay, that it's apparently you've apparently breached my right for respect to private and family life, but without actually providing any substance or detail or basis for that statement. Yeah, and that I've been discriminated against, but again with no actual factual basis, no what happened, where it happened, when it happened, etc. But it all sounds very scary and convincing until you start to look under the surface and go, but there's actually no detail in any of this. Okay. And then obviously what it tends to go on to say most of the time are the two bits in yellow, which is what I want is this disciplinary process suspended pending a full review, and what I want is an independent and impartial investigation. I've seen that in a number of examples of, let's say, AI generated challenges to disciplinary processes. Practical challenges, well, as we've seen, and you may have this experience yourselves, what we are seeing is the length of grievances or the length of submissions or the length of statements that people want you to take into account in disciplinaries are growing. It takes a few seconds to create multiple page documents, unfortunately. We're also therefore seeing the volume of correspondence within disciplinary processes or within grievance processes growing significantly. And the speed in which employees are now responding to letters, to correspondence through using AI is making it somewhat overwhelming for employers to deal with from time to time. And as we say, the accuracy of what's being submitted is variable to say the least, because as we've just seen, you can produce very nice looking, nice reading documents, but that don't actually contain any actual fact or details of relevance. And the style is often verbose, so that's coming from a lawyer, overblown, overly emotive, and sometimes just over the top for what's actually being put forward. It also has a habit of trying to be too lawyerly, because that's what people want it to sound like, because that apparently will carry weight and get them what they want. But as we say, lacking in actual facts, high on conclusion, high on submission, but not on what supports that submission. And as we've seen, they are very optimistic tools. They have the habit of telling you what you want to hear. Okay. There are also then wider issues about the data risks of your employees using these tools, particularly if they are using tools outside of your systems, if they are putting in details about employees or details about company sensitive matters into these external tools. Okay, but we'll come back to that later. As we say, they can appear very convincing, and if you don't know what you're talking about, they start quoting case law at you and quoting from that case law at you. It can be very, very intimidating and very time consuming to read and to verify what is actually put in there. It takes us time even to look at these letters and verify when they start quoting all these cases as that any of it's correct or not. Okay, and looking at it from the other side, sometimes the employee has a point, but they wrap it up in so much AI generated nonsense that you lose the valid point they're actually able to raise. So what can we all do about this? I think it's fair to say at the moment, it's difficult to know quite how we stop this or quite how we control this, okay? So we've tried to have a think about what you could do. We don't necessarily have all the answers to how we stop this problem or tackle it effectively, but we're open to any suggestions if anyone out there has any particular things they've done that is helping to address these concerns. So what you can do, well, always go back to what your legal obligations are, okay? With grievances, there is no grievance statute. There's no statutory grievance rules as such. What there are implied contractual terms in every employment contract that says you as an employer should give prompt redress to grievances, and there's also this super implied term of general mutual trust and confidence, okay? If you don't give appropriate or prompt redress to grievances, you potentially face constructive, unfair or wrongful dismissal claims when people resign because you haven't properly dealt with their grievances. That's about as specific and detailed as grievance law strictly gets, okay? There can be wider cases where not dealing with a grievance land you with an accusation that you're detrimentally treating somebody for a different reason, say whistleblowing, or you're discriminating against them, you're victimizing them, etc. But that's strictly discrimination law or other laws where the grievance is the act or the failure to act, okay? But generally, the law isn't particularly specific on how you deal with grievances, okay? You'll of course all be aware if there is an ACAS code of practice, but breach of the code itself is not actionable. You can't sue for breaching the code. You sue for constructive unfair dismissal, and if you didn't follow the code as an employer, you can face an uplift in compensation, and in deciding whether a constructive dismissal is unfair, they will take into account whether or not you followed the code, okay? You will also get quite a lot, and we've seen this a number of times, we've seen AI tap into what's called ACAS guidance and quote various things in letters from ACAS guidance. Do bear in mind that ACAS guidance, unlike the code, is not something the tribunal has to take into account, okay? It doesn't have that authoritative status, okay? So just be aware when people are quoting at you from the code, that's different to quoting at you from the guidance, okay? The guidance runs to 60, 70 pages, the code runs to 20 something, yeah? What is a grievance? Well, there isn't actually a legal strict definition, but the ACAS code gives a very broad definition. I won't bother going through that in too much detail. And obviously all it actually says in the ACAS code is that you should raise, employees should raise and employers should deal with issues promptly, not unreasonably delay meetings, decisions or confirmations, carry out necessary investigations to establish the facts, have a meeting, have an appeal. There is no specificity as to how you control the process for employees raising grievances or making submissions within grievance processes, okay? And what it says is obviously if they can't raise it properly, then basically they should raise it in writing and set out the nature of the grievance. That's as specific as the code gets, okay? And then you arrange the meeting and you attend the meeting and then you give them an outcome, okay? I won't worry too much about this because I'm conscious of getting on to it. And then obviously in disciplinaries, what we are seeing is that AI is tending to be used to launch, let's say, often long and over the top challenges to the process being followed, okay? It also tends to be used to submit statements either during the investigation process or ahead of or at a disciplinary hearing, challenging various aspects or putting forward mitigation. And unfortunately, it does tend to lead to lengthy, complex submissions. And what we are tending to see is a growth in the employee arriving at the disciplinary hearing with an AI-generated 12-page long statement, raising multiple new points that is then leading to adjournments of hearings because the person hearing the hearing looks at this very convincing sounding, poshly created AI document and goes, I can't rationalise or process all of that right now. I'm going to have to take it away, and then you're ending up with adjournments and delays in disciplinary processes. Okay. So what can we do with this problem? Well, I don't have a magic bullet for this one, I'm afraid. I don't have a one-size-fits-all solution. If anyone out there does have that, we'd be grateful to hear about it. But in a way, it's kind of knowing that there aren't necessarily easy solutions to this one. So can you ban the use of ChatGPT et al. for drafting grievance and disciplinary submissions? I can't see how you can, because even if you have a policy saying you're not allowed to put company data or personal data into these external devices, which many of you may now have, as you've seen, you can generate pretty convincing looking letters and documents without the detail, and then add the detail in yourself. So just saying you're not allowed to produce something using AI is, I don't think, going to be a reasonable or acceptable position to adopt. Can you put word limits in? Well, or can you insist they use a specific form as a way of trying to control the content, the volume, the scale of what's being submitted? I know a lot of employers do have specific grievance forms. So if you have a specific online grievance form, you can probably set specific word limits. But ultimately, if this employee then wants to use AI to put more in, they will just generate it and email it to you anyway. But this might help. Sounds practical and simple, but it might help. Also, having an online specific form can help to guide them in terms of actually getting the information from them you need to look at the grievance properly, rather than what AI has just generated in a posh looking letter. Okay. What we are seeing an increase in is employers getting grievances that are generated by AI and simply going, that's great, let's have a meeting and discuss it. Because we are seeing a lot of employees hide behind the AI rather than want to come and actually talk to you about what their grievance is when they don't have that backup. Okay. And actually, the way you get to the bottom of this is great, your 10-page document, but what's actually this really about? And what's actually really the issue? Because it may not be what your letter says, because in some cases you don't really even understand what your letter says. So get them in a room, go through it, pull out of it what the grievances are actually about before you waste hours and hours and hours trying to investigate what's in the letter. Okay. Can you dismiss an employee for submitting a grievance that contains hallucinations? In other words, you submitted a grievance that contains grossly inaccurate material. I think you're going to struggle. We'll see how that develops over time, but I think you'll struggle at the moment because you're dealing with employees, not specialist lawyers. Yeah. Quite often what they submit in grievances is not correct or not upheld. You don't normally then go and discipline them unless you can prove it's been malicious, or in effect this is they've raised their 18th AI generated grievance in the last 3 months, then you can deal with it for just the sheer volume of it and not for the fact it's AI as such. Okay. Can you improve your ability to address issues at the informal stage? This is a difficult challenge, but the best way of avoiding the AI grievance and disciplinary debacle is obviously to nip issues in the bud before it gets to the point where they've built up enough a level of aggravation that what tends to happen is you get this AI grievance that goes back years and raises issues that should have been dealt with informally, face-to-face, over time, ideally. And the more you can do that, the less you get to a point where you get some 20-page mass grievance, as it were. Okay. And just be careful when you do get these letters. Try not to get drawn necessarily into point-to-point dealing with it. Sit down with the employee, understand what the grievance is really about, understand what the real issues they want responded to actually are. Sometimes that can yield a much narrower, a much easier to handle process. Do you have grievance guidance? We all have grievance policies. We all say what a grievance is, but do we actually give employees any guidance, or whether it's through a form for submitting it, whether it's through guidance on what to consider if you want to raise a grievance? Do we have any guidance? Emphasis on fact, emphasis on what happened or didn't happen, when, where, who, why, and what it is that you're therefore concerned about because of that. Because as you've seen with the AI generated stuff, it's very good on what the concerns are, but it's not very good on what actually happened, when, where, who, why. So you can try to help yourself by having some guidance. Whether employees will follow it is a different question. Can you ban the use of these tools because they're disclosing sensitive data? The difficulty is you can have rules about saying don't put company data or our personal data into external AI tools. But obviously, as you've seen, you can create these documents without doing that. And also, even if someone were doing that, it would be pretty hard to prove unless they admitted to it, because it's hard to know what prompt they've actually put into the system in the first place. But the reason that a lot of these grievances, as you've seen from my own examples, are pretty thin on the facts and heavy on the unsupported accusations is because I suspect people aren't putting facts and data into them. They're just putting the accusations into them and saying, write me something that raises these accusations. On the disciplinary side, as you say, what we are seeing is employees almost going through the investigation process and then being given the investigation outcome evidence ahead of the hearing and almost feeding that evidence into AI and going, come up with my submissions and my counter arguments, and then turning up at the hearing with a 9-page document, or which they want to read out there and then, and it's causing disruption and delay and the need to adjourn hearings. So, query, can you require someone facing a hearing to submit any such written submissions a number of days before the hearing? Otherwise, you won't take it into account. I've seen policies that say that. You have to provide us with anything written in your documents or so on and so forth a number of days before the hearing. The difficulty is that it's not legally certain that it would be a sound and fair process to ignore a submission that was, say, brought on the day or provided just before the hearing, or even arguably provided after the hearing before a decision has been made. So it would be a risk in terms of the fair process to set such an absolute rule. But you can have a rule as long as you are prepared to bend or break the rule, because it might still have some preventative effect, if that makes sense. Yeah. Can you discipline an employee for bombarding a process with AI-generated challenges that turn out to be incorrect or misconceived? Again, it is difficult unless you can prove that the employee is acting deliberately maliciously in what they're doing. The fact that they're producing a volume of correspondence to try and defend themselves, and the fact that it's AI generated, and the fact that it's full of nonsense, isn't necessarily a clear basis for, let's say, separate disciplinary action. The only other key tip we would have is that in the age of AI, you need to be fully aware of what your own policies and procedures actually say you will do, and ensure that you follow them to the letter where possible. And if your policies do not reflect what is possible, now is a good time to look at them and amend them to give you greater wriggle room. Because in the age of AI, I don't have to spend 2 hours reading a 30-page disciplinary policy. I just have to feed it into an AI machine and go, tell me where I can challenge this, and it will give me a nice list of points I can challenge from your own policy or procedure in half a second. That means that I can attack your policy and procedure if you are not following it correctly a lot easier than I used to do. And we are seeing, therefore, employees employ these tactics of, to be fair, quite rightly, holding employers to the letter of what their policy said they would do, and a lot of employers finding out that what their policy says they could do, they may not have done. Okay, doesn't always necessarily undermine the fairness of the end process, but it doesn't help. I'm just going to read a question that I've got to see. Could or should you have a company policy on AI? Yes, you should. And you need to look at it with whoever's in charge of data protection in your organization. But you also need to think about, with AI, you need to think about whether or not you are allowing employees access to AI to do their job, and also what rules you say about their use of AI with any company data or personal data. To put that in context, we have an AI system, we have access to Copilot, but our AI system is what they call an enterprise AI system. In other words, it's private to Brachers. We can put stuff into it, it is not shared with the world, it is ours. Okay? If I go and put that information to a public ChatGPT, let's say, it's shared with the world. I've given that information away, I've arguably breached confidentiality, etc. So be careful about distinguishing between using AI systems you govern and control, that are often called enterprise systems, or public AI systems where you do need to have stricter rules on what your employees should and shouldn't be doing with those systems, because you are in effect giving away the data you put into them in many cases to the people providing those models. Okay, so if you haven't got an AI policy for your workforce on when and how they should use it, yes, it's something you need to look at. Right, I am conscious that we have reached the time for today. I hope that's been of some use, even if it was to realise that there aren't easy answers to this solution, and that nobody else has any particularly simple one-size-fits-all solutions to this issue. And it's unfortunately, I think, one that's going to be with us for the foreseeable future. And we'll just have to see how things develop in terms of what employers can do to tackle, let's say, the over-enthusiastic use of AI within these areas. On that note, thank you for coming today. When I close down the session, there will be an exit survey. I know some of you do fill it in. If you can fill it in and give us any feedback, particularly on what you'd like to see in sessions going forward, that would be greatly appreciated, because we do look at it and then we can take that into account in what we do in the future. Thank you for coming for today, and have a great day.